Hello, my friends. And thank you so much for choosing to spend part of your Monday, December 11th, with today. The plaintiffs were required to respond, as you know, to the defendant JHACH's ridiculous motions. And I don't know why I had YouTube open in another tab, but that is a big no-no on StreamYard, as we all know, or those of us who do this know, because then you get confused because there's a 10-second delay. So here we are. And so many of you asked me to cover this tonight. So I scheduled it because it takes a lot of prep to do these kind of shows, because you got to read the documents. You got to know about the documents. A lot of times we do the documents cold, which is cool too, because, you know, I can do improv. I'm good like that. I can analyze things on the fly. But this took a lot more prep than I thought it would. So I scheduled it for 10 p.m. Eastern. And then as I was getting ready, I saw that someone else decided to cover it live too. So, I don't know if you guys still want to do this, if you want to do something else. I am very flexible. I am very fluid. So we can do whatever you want. It just seems like there's like 1,700 people watching it somewhere else. So I'm here for you guys. Let me know what you want to do. A lot of you requested that you wanted to do this, but while we're waiting, I found a little footage of Maya that was published yesterday on a local Florida news channel. And I thought we haven't seen Maya in a long time. So let's take a look at Maya for a second while we wait for perhaps some other people to join, since it is late here on the East Coast anyway. Let me just get rid of that one and pull up this one. And let's see. Maya gave an interview to First Coast Connect that was published yesterday. So let's see if we can play a little bit of this and have some commentary in between. And this was like a local Florida reporter who did some live call-ins and had some people calling in with questions. Some of the people who called in kind of rambled on and on about their personal stories. So while this is about 30 minutes long, if you want to watch the whole thing, you can just search this up in your YouTube search engine. But let's listen to Maya talk a little bit about how she thinks this verdict has affected people.
Thank you, Sabrina. Maya, what kind of feedback have you gotten generally about um, what you've gone through? I would imagine you hear some of both sides.
I do hear some of both sides, that's right. But I would say the majority has been positive. I don't really go on my social media and scroll through comments and read them. So
Great advice. Great advice. Take it from Maya. People, do not go through the comments and read them, because they can be very upsetting. And at 17, she knows that probably better than I do. So I don't know, it just strikes me that she kind of looks so much more grown up than she did in the courtroom already. I mean, she's been through so much. And is it just me, or does she look like just so much more grown up? Beautiful Christmas tree. Her eyelashes are amazing. And let's see what else she has to say.
So if I'm on my phone and I get a comment and it's negative, that's the only way I'm going to see it. And most of them I just dismiss because it's very evident that they haven't watched the trial or they haven't even watched the documentary. It doesn't really get to me, the negative, and I'm glad that it doesn't, because it just gives more room for the positive to fuel me.
And when someone like Sabrina has a message for you that she finds the story inspirational, how does that affect you?
It makes me so emotional. I was actually tearing up as that was playing, and it's hard.
Oh, somebody just said she's 18 now. Her birthday was yesterday. Happy birthday, Maya. Oh, that's amazing. All right, so she's 18 now. She really is an adult. At least she can vote. She can't drink or smoke a cigarette, but she can vote.
breaks my heart that other people have similar stories. But again, it just makes me want to move forward with everything.
So there's some legal battles that lie ahead. There is a hearing, I believe, a week from Friday that is going to discuss a number of things, but the defense in this case is raising questions about the integrity of the jury. Can you talk a little bit about that, Greg?
It's unusual, but they have gone after one juror in particular. We called juror number one because that was the selection process. He was assigned number one
And the foreperson, is that right?
and ended up being the foreperson. And he asked probably the most probative questions throughout the case, but he asked them of both sides.
As we know, because we were watching juror number one very carefully, because we knew they were trying to get rid of him. Going to have to keep interrupting this interview. Sorry about that, but that's the way YouTube rolls. Got to keep breaking it up, giving commentary, or they copyright strike you. So as I learn these rules, Georgina, where is that first, the free kill law? Is it in the beginning of the interview? Because I kind of skipped to the last third. But if you think it's important and we should watch it, we can certainly scroll back.
And at the start, I thought that he was very pro-defense because of the questions. Really getting into, now, how can you prove this? How can you say that? And then when they had to prove their case, he was equally as inquisitive, let's say, of their case. There's nothing to these allegations. I think that they made up their mind that because his questions were so intelligent, knowledgeable, and were probing the negative aspects of their case, that they just decided he must have taken over the jury, and then there was some flaw there. And
They're also, though, saying that his wife attended the
Well, that's
trial and was
ridiculous.
posting on social media about the case in a detail that perhaps a spouse ought not know.
Yeah, except that we proved every single one of those that the phrases had come up in the trial previously. And so the whole idea was that the juror knew about a particular phrase that could only be found on one of the doctor's web.
Who knows what that phrase was? Who can name that phrase? We all know what that phrase was. And they said the only way that juror number one could know that phrase is if he went onto Dr. Kirkpatrick's website. And we knew that it was in the testimony. And so many of you with your eagle eyes and ears pointed to exactly which witness used that exact phrase. I know we're on a 10-second delay. There it is. There it is. That's it, Shauna. Shauna Banana. Creature Comforts. You are correct. Susan knows. Skoda, that wasn't you. Colleen McVeigh. Betty. Creature Comforts. That is correct. Ding, 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 ding.
Websites. Well, then we proved that one of the physical therapists had used this term, creature comforts, in her testimony. And creature comforts is not that unusual of a term. And so a big part of their theory was, well, since he used the term creature comfort in one of his questions, that must mean he's talking to his wife. And that absolutely positively wasn't true. Judge Carroll asked the jurors every single time they came back, even for a 5-minute break. Now, have you spoken with anyone? Have you read any media? Have you learned anything about the case? Have you talked among yourselves? And no, 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 and no throughout the whole thing. The defense has really been chasing their tail on this one. And I'm very confident that the judge is going to deny that motion.
Maya, there's also a new recently filed lawsuit against the hospital. If you're comfortable talking about it, Maya, what is that about?
This newly filed lawsuit, and I think Greg Anderson is going to say that he's going to file it. I can't find it in the system yet, so I don't know that it's been filed, but you guys are really on the court website so much more often than I am because I have so many cases to check in so many different states and counties. But I don't think it's been filed yet. And I think that's what Greg Anderson is going to say, that it's going to be filed. So let me know if you know any differently.
It's about another incident that happened while I was staying at Johns Hopkins All Children's Hospital. As Greg has stated previously, we have tried bringing it up in court. As a matter of fact, I did a proffer on it without the jury present. The judge didn't really want it to come in since the jury wasn't questioned pre-trial about that specific topic. It's just a very emotional thing for me. It's hard for me to get into, but yeah.
That's all right. Greg, what can you tell us about that Maya's comfortable talking about?
Well, there was an incident involving a doctor that came in without an escort and, let us say, disrobed Maya under some extremely suspicious circumstances, and other things went on. And we did not know about it. Maya, I believe, firmly had suppressed it, but we were able to confirm in some of the psychological records that she had tried to tell the pediatric psychologist there at the hospital about it and was shut down in that. And it wasn't until I think 2 weeks in that I had a conversation with Maya and I said, "Now, Maya, you got to tell me every single thing, every single time anybody at that hospital touched you, no matter how slight or what the circumstances were." And finally, Maya explained what had happened, and I was horrified, absolutely horrified. But as an attorney and officer of the court, you don't just come in. I believed Maya. Maya has.
If anybody doesn't know what they're referring to, there was a note, I believe it was in one of the, was it a psychiatric note in the hospital that Maya actually tried to disclose this while she was in the hospital, that a man that she thought was a doctor came into her room alone without a chaperone or an escort or a nurse or whatever they call that second person that's supposed to be in the room. And he said, "Oh, I'm just here to take a look." And he pulled the blanket off of her, pulled down her pants, took a look at her privates. I try to keep it clean on this channel and classy. Stared at them for quite some time. Maya burst out into tears, became very, very upset. Then he left the room. And there is no indication about whether he was, in fact, a doctor. There's no record of this person coming into the room. Anderson, when he found out about this during the course of the trial, tried to amend the complaints. That's exactly what he said. "Can I take a peek?" Colleen, you are correct. "Can I take a peek?" Under the guise of doing some sort of medical examination. "Take a quick peek." That's what he said, Skoda, right? Gross. And when Greg found this out during the course of the trial, he tried to amend the pleadings to allow the judge to allow this evidence in and add a cause of action for this CSA or SA. And the judge denied the request of the motion because he said that the jurors were not properly questioned about such a claim during voir dire. And I agree with that decision, probably made the right decision. But this was something that Greg Anderson says and continues to say, and it will say now, that he believes that Maya actually repressed. It was a repressed memory that sort of came up during the prep for this trial. But he does say, and I think she told someone more contemporaneous with the event when it happened. So, there's evidence that it happened. And I believe they are going to file a new lawsuit against JHACH for that incident. As if everything that happened to her wasn't bad enough.
Never misrepresented a thing to me, was never caught in impeachment at trial. I knew that this had happened, but I still went out and found corroborating evidence in medical records where she had tried to say something about it and people had not followed up. And also found independent witness. And then I asked the court, "Can we bring this in?" Because I had already raised, obviously, abuse as one of the issues and a battery count. And the court listened, and I think part of him wanted to bring it in. It definitely was part of this story, this circumstance, and what happened to Maya. But he felt as though the jury had not been questioned specifically about sexual assault.
Mhm.
battery. And he did not believe that that was fair.
I agree with that
And
decision.
so we made clear at the trial we were going to bring a separate suit, and we have.
That's right. That's right, Lorraine. She told Katzenstein and the psychologist, or Katzenstein was the psychologist. It's in the records, not mandatorily reported, although it should have been. So while they did not call, DCF or make that child abuse hotline complaint regarding what happened to Maya, they did in fact make 2 calls to the child abuse hotline against Beata after the first one was closed because of the corroborating evidence of the fact that Maya in fact did have CRPS. But interesting though, they didn't make a call for this complaint. Or maybe
Maya,
not.
just kind of final thoughts here. This is a big settlement. What is your plan? What intention do you have to do with the money? What is your plan for your own future at this point?
Well, I think that I would personally really enjoy to use it for some family time, like vacations, and eventually moving out of this house. But we do have bigger plans with the funds. I think it'd be really neat to make a foundation in honor of my mom, and it would be directed towards CRPS and possibly victims of wrongful kidnapping from hospitals.
Mark called. He said he wanted to thank Maya for making her story public. And we certainly thank both of you for being here today. Maya Kowalski, thank you for joining us via video. Greg Anderson, thanks so much for coming in studio. We appreciate both of you being here.
So I thought that was a really good interview. Georgina, where is that information on that law that you're talking about? Closer to the beginning? I kind of feel like I watched the beginning, and I watched some of the phone calls. I don't recall seeing it. You're sure it's in this exact interview? She is precious, isn't she? Mr. Skoda loves to call or come by during Melanie's live stream. All right, Skoda, we'll forgive you. Somebody also was kind enough, more than one person actually, was kind enough to to email me and to tell me that I should be careful because they're coming after me in the Maya subreddit thread. And, they're talking about me, and they're talking about, somebody said something like, who is this Melanie Little? Does she even have a license to practice law? Is she even licensed to practice law in the state of New York? And I am, by the way, I am. I'm not on here, making up my credentials. And somebody said, yes, she even gave out Howard Hunter's address. And then people were freaking out like, she gave out Howard Hunter's address. That's horrible. That's horrible. Howard Hunter's P.O. box for his office. I'll repeat it again for those of you who didn't get it the first time. And if you think you're going to complain about me to the Bar Association for doxing Howard Hunter's public P.O. box address to his office in Tampa, or whatever it says on the public court filings, please go ahead. That's pretty much the worst, the most ridiculous thing I've ever heard. I don't know who's in this subreddit, who these people are, but it's okay for your boy to dox a juror who's doing his civic duty with his name and address in a public court filing. But if I, as an attorney, am reading my viewers the court document and I read Howard Hunter's P.O. box office address to his office, you should file a complaint against me with the New York Bar Association. Good luck with that. So never fear, my cupcakes. There's no basis for any complaint against me. And they can lurk here all they want. Maybe they'll learn something. I do respect all opinions and all differences of opinions, but, state them with respect. You don't need to personally attack me, my viewers, my mods, or each other. Because we don't play that here. We don't tolerate it. It's part of the deal. It's my channel and I can do what I want. And my mods are the best on YouTube. They really are. They kick out the bullies and the nasties and the cursey words and the foul language quickly too. It doesn't last long here. So that's why a lot of patients who have CRPS and other chronic pain disorders found this a safe place to watch the trial analysis and trial commentary. We didn't live stream every day. I don't have 8 hours to spend with you guys every day, although I wish that I did. But what I would do is take the pertinent portions of the testimony and we would put them together and watch them on the same night. For example, we did Dr. Corcoran and the defense expert, Mr. Anderson, on the same night. And we did a Battle of the Experts show. And then one night we did the testimony of Kathy Beatty and Sally Smith on the same night during the plaintiff's case. So we kind of mixed it up a little bit. And I thought we had a lot of fun. Howard, you got mail. Mark Blaine coming in hot with some funny stuff. Lola May can be a fierce cupcake. Layla May, I called you. I'm my dyslexic. I don't know. I just juxtaposed all the letters in your names. All right, Georgina, we will do the plaintiff's responses that I prepared for. And thank you, Jade, for keeping it clean and liking that we keep it clean here. I don't know, just feel like we should have a respectable place to come. That's all. People say to me, why do you get dressed up when you want to think? Because it's just respectable. I respect my audience. I'm not going to show up here in my pajamas. I'm just not. It's just not me. That's just not who I am. Okay. I'm not a highfalutin New York attorney who thinks she's better than everyone. Like someone commented about me the other day on another channel. Smug and arrogant was another thing that I got. But to each his own. I'm going to tell it to you like it is. And you know that. And that's why you like it here. And that's why you're here. All right. So if you guys want to, you can search up that entire video and you can go watch that later. But let us go now, shall we, my cupcakes, to the plaintiff's response to the defendant's motion for new trial. Remember, here's what their argument was in a nutshell. We didn't do it, but if we did it, it wasn't really that bad. And if it was really that bad, well, we didn't cause it. But if we caused it, you really shouldn't award them that much money. So if you do decide to award them some money, award them this lesser amount of money that we think that you should award them. But really, we don't think that you should award them anything. So what you should really do is just overturn the entire jury verdict and let us win. Okay? Thank you. Love, Howard Hunter. Not going to fly, folks. Not going to fly. But let us see. And listen, I have to give credit where credit is due. This is a very measured response. You know how emotional I get about this. I got very emotional about this the other day when we were talking about them accusing juror number 1 of using Nazi symbolism in his note to the court. I just thought that was so far beyond the pale that it was unlike anything I'd ever seen. And I didn't think that we should be subjected to all that. But here we are. Let me see if I can get this in a better kind of format. Let's see. All kinds of noise going on outside right now. Oh, Miss Scarlett, you know how much I love you with all of my heart. I'd say it's having standards, not being smug. Thank you. Thank you for that. I try. I don't know. I was preparing a show on Karen Reed, but I'm going to save that for you guys for another day because I have a lot to say about that. And I don't understand why you can't always back the blue, and I do back the blue. So I think that John O'Keefe's death should get just as much respect as the people who may be trying to cover something up. But hey, that's a story for another show. And here we are. Why can't I just make this? All right. Here we go, my people. Plaintiff Jack Kowalski's response to defendant JHACH's post-trial motions. So they're putting their response to all 3 of those things we talked about, the directed verdicts, the motion to get a new trial based on several issues, including the juror misconduct and also the motion for remittitur, which is a reduction of the money damages. They do think that too much money was awarded, and by all means, it should definitely be cut down. What they did not respond to today was the Nazi portion of juror number one's alleged, the last thing that they filed on. What night did we do that? All these days are blending together. Friday, I believe, Thursday. They did not respond to that yet, but as we know, we think juror number one is a KISS fan, and that's why he wrote his S's that way. And really, that whole argument didn't make sense anyway, because they couldn't decide whether they were trying to say that juror number one saw Sally Smith as a Nazi who was holding Maya, a medical prisoner. And remember, he wrote that note to the court immediately after he had watched Sally Smith's deposition testimony. And even if he did think that she was Nazi-like, that would not preclude him from serving on the jury. But then again, how would he even know those symbols really unless he held those beliefs? So the whole thing was so off of a Reddit thread that it was a little bit mind-boggling that an attorney in good standing would file such a thing. But hey, we're here for it, I guess, right? Okay, this is 89 pages. I have highlighted relevant portions of it. And what I think we will do is it's so boring if I just read it to you, so I'm going to try and explain it to you as we go. If you have any questions, please put them in the chat, and we will break every so often to go over some questions every section, let's say. Okay, let's do that. Introduction. This is a very excellent introduction because it is going to give us an entire breakdown of everything that the plaintiff thinks that they have proven, and a lot of things that will sort of be summarized for us here, which is really, really a nice summary. Defendant's 144-page motion shows defendant still does not get it. Defendant now blames this court and the jury and continues to maintain there was nothing wrong with the way it treated Maya and her family. Defendant argues in its motion that any injuries suffered by the family were not so bad, were the family's own fault, and any harm visited on Maya, Beata, Kyle, and Jack was caused by DCF because defendant was simply following DCF's orders. As the manifest weight of the evidence demonstrated, Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, each of whom defendant accepted responsibility and liability for, did the following. And that's important because we were talking about why Kathy Beatty was discontinued against immediately prior to the beginning of the trial. And the reason for that, in my opinion, is that the hospital had already accepted liability for her actions. They admitted that she was an employee, and there was no need to have her in the case any further. It may have just muddied the waters. I think it was cleaner just to have her out of the case altogether. Hello, Robbie. Oh, sorry, guys. I forgot to take that comment down. Hi, Robbie. It's good to see you here. Hello, Peter, one of my amazing mods. Patroness Glow, another one of my amazing mods. I know Robbie's in here somewhere. Hi, Robbie. Hi, Robbie. It's nice to see you. Robbie's in Australia, so the time change is a killer. And sometimes we got to do it so that people from other time zones get to watch us live. So here's what the plaintiff says. The manifest weight of the evidence demonstrated that JHACH did the following. 1, negligently and almost instantaneously changed Maya's CRPS diagnosis over the weekend of October 7th, 2016, although Maya's diagnosis had been confirmed by no less than 5 outside treating anesthesiologists and neurologists and recognized by the defendant hospital on each and every of Maya's approximately 20 previous visits and admissions to JHACH. Isn't that a nice, concise paragraph of what JHACH did upon her admission? She was admitted on October 7th, and that weekend was when they changed her diagnosis, even though she had been there 20 times before and it had been confirmed by at least 5 outside medical providers. They also kept Maya in the hospital from October 7th to October 13th without legal authority and despite her parents' repeated requests for discharge. If you are new here, we have discussed this several times that under the Patient Bill of Rights, Maya and her parents had the right to have her discharged, to have her leave that hospital. AMA, which is also known as against medical advice, regardless of what the hospital knew, thought Beata might administer to Maya when she got home as an infusion nurse. She had the right to leave. She was not in state custody until after that date, and she had every right to leave. They threatened that if they tried to leave, they would call the police. They had security. It was a whole big thing. They also refused to transfer Maya unless her parents signed off on the defendant's suggested diagnosis of Munchausen by proxy, MBP, and admitted that Beata had a psychiatric condition that led her to physically and emotionally abuse her daughter, parens, only to hide behind its status as a pediatric hospital and claim that it had no ability to diagnose an adult like Beata. Something else we have discussed at length. This is a children's hospital. They did not have anyone on staff who was qualified to diagnose Beata with a psychiatric condition, and yet they did. They also covertly videotaped Maya to try to prove she was participating in a, quote, charade to assist and cover for her mother, who had fabricated Maya's CRPS, and in doing so, placed the commode out of reach so that Maya would be forced to get out of her hospital bed when she thought that no one was watching. Parens, instead, she defecated on herself and was dragged to the commode by hospital employees. And we did listen to Jack testify about that as well. They also assigned Catherine Beatty, an employee with at least 3 documented disciplinary and anger management issues, to be the primary overseer of Maya. They allowed Beatty to repeatedly engage in unwanted contact with Maya, including hugging, kissing, patting Maya's legs, and placing Maya in her lap. Those are the batteries that we've discussed at length. They also forced Maya to endure physical therapy without pain medications and enticed Maya to push beyond her limits by enticing her with the promise of chocolate cake and going to church outside of the hospital, only to be told by Beatty that she had not tried hard enough and would not get chocolate cake or go to the outside church. That was another idea that someone had for a t-shirt: let Maya eat cake, or I forget what the other idea was. You guys remind me. I love something like Maya loves cake. I can't remember what it was. That was something else that the Redditors were squawking about me, that I was selling Maya merch to make a buck and to try and milk my audience. And they forgot to mention in their little thread, because, you know, selective facts, that all of the money, all of the proceeds that we make from the Team Maya merch that I designed is going to CRPS research. So I don't know if anybody's on Reddit, if they've seen those threads, but, you know, just chime in, because they apparently don't have all their facts. Here's something else the hospital did. Routinely interfered with Beata's visitation rights, allowing Beatty to sit in, interrupt, and disparage Beata by making inappropriate faces, rolling her eyes, and otherwise, quote, acting like a toddler, end quote, while Maya was on the phone with her mother. They required Maya to keep her hospital room door open while having what should have been private conversations with her attorneys, Michael Kelly and Mark Zimmerman, and rationalizing this infliction of emotional distress with the implausible excuse that the hospital staff had to keep the door open for fear of Maya falling and being left on the floor by her attorneys. And if you recall, during the cross of one of the witnesses, I can't recall which, I think Greg Anderson said, "Do you really want this jury to believe that Maya's attorney would let her fall on the floor and would just leave her there, and that's why you had to leave the door open?" JHACH also provided less than 5 hours of cognitive behavioral therapy, or CBT, over Maya's 3-month admission, even though CBT was, according to defendant and its experts, one of the pillars of therapy for Maya's CRPS. They forbade Maya from engaging in religious practice, despite the hospital's own patient bill of rights and in the absence of any dependency court order authorizing such a prohibition, including removing Maya's artifacts from her room, instructing Maya's priest from her family's church that he could visit but not pray with Maya, and kicking out members of Maya's church who visited as part of the Legion of Mary with the good faith intent to leave Maya with a statue of Mary to watch over and comfort Maya. You will remember we watched the testimony, I think more than once, of, I think the woman's name was Linda Brown. Correct me if I'm wrong. She was a woman who came to visit Maya in the hospital. She came to church. I mean, not to church. She came to court with an amazing hat on, and she was so kind, and she had a rosary, and she was showing prayer cards, and she brought the traveling Mary to Maya in the hospital, which is a really big deal. And she was turned away, and I thought she made an excellent witness. And I think it was it Tori Nias who confiscated the Eucharist because the hospital personnel thought it may be dosed with liquid K. So, I mean, you just can't even make this stuff up. They habitually lied to Maya, as documented in the defendant's risk management file, telling her that her illness was, quote, all in her head. Her mother was in a mental institution, and Beatty would be her mother now. I think that speaks for itself. They sought to drive a wedge between Jack and Beata by suggesting that Jack considered divorcing Beata. They forbade Maya from having contact and social interaction with other children on her floor, and further dehumanized Maya by not even placing her name on the door of her various hospital rooms. They refused to deliver gifts that Beata and Jack brought to the hospital for Maya, including a birthday card to commemorate Maya's 11th birthday and a white Christmas dress, one of Maya's favorites, sent to Beata. Both meant to remind Maya how much she was loved, since she was forced to celebrate these occasions alone in the hospital. They refused FaceTime calls between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls twice daily at 11 a.m. and 5 p.m. They stripped and photographed Maya over her objections and tears without her parents' consent, and under Beatty's threat that if she did not allow the photos to be taken, she would not be allowed to attend the dependency court hearing later that morning. They conducted a relentless intimidation and harassment campaign against Beata, beginning with the refusal to honor Beata's requests for Maya's discharge in the first week, with knowledge that the hospital's actions were driving Beata towards suicide and abhorrently predicting Beata's final act. And there, my friends, in a nutshell, if you did not watch this trial, that is everything that the plaintiff intended to prove, and in my opinion, did prove during the course of this trial. And apparently the jury believed it too, because they came back with a $261 million verdict in this case. Let's go to the chat for a moment, shall we? See if you guys are doing all right. Betty says they cannot give Maya's family enough to make up for the mistreatment poured upon that family. I would agree with you. Pam Spraggins, thank you for becoming a new member. We appreciate you so much. Julie says, spread the word, greatest channel. Goal to get 20,000 by January 1st. Melanie's common sense and informative. Thank you. Thank you. Thank you. Yeah, let's get to 20,000. We're almost there. We're like at 18,100 and something, which is pretty good since I just started this channel end of June. Yeah, 6 months. All right, we'll get there. I hope. Hit that like button. Chantal, thank you. We want you, Melanie. Thank you for your super chat. Oh, and Robbie, thank you so much for your super chat too. Hello, everyone, and hello to you. We have missed you. We enjoy it when you're here because you are an excellent contributor. So many of you are excellent contributors in this chat. and have such great points and really pay attention and really have such kind things to say. Articulate velociraptors as the defense chastised the Kowalskis for taking money away from kids with cancer. Well, JHACH pays their lawyers to do handwriting analysis. You know what? Articulate velociraptor? I don't even think they had a handwriting analyst. They did not even have an expert for that little motion that they submitted last week on the first night of Hanukkah. That's when it was. It was the first night of Hanukkah. They filed their Nazi papers on the first night of Hanukkah. Georgina, I've lived a long time and have seen this with my own eyes all my life. People are cruel. Clicks are super cruel. Susan, you keep changing your name, but I know it's you because I see the picture. Reddit is free. They just pay them to read Reddit. They're paying people to read Reddit. I think you're right. They did. They got that exact idea from Reddit. It was like a cut and paste. It was like what we call scratch and sniff motion, same kind of motion, just scratch and sniff. The names and dates use all the same case law when you're trying to prove the same thing, which I would never do, but people do that. And kind of like scratch and sniff your legal arguments from Reddit. Guess ChatGPT was off that day. Thank you, Truth Seeker. I subscribed to your channel when you first started. Always enjoyed your visits to other channels. Thank you. Thank you very much. We do cross-pollinate quite a bit. SCOTUS said that same subreddit did a poll today on whether they believe Maya has CRPS, said she manufactured her lesions, and one guy said she doesn't have CRPS because he doesn't believe it exists. Okay, all right, the deniers are out in full force. Full force. Hi, Z. Have you heard that bar complaints have already been filed? Not sure if by juror number 1, though, but he deserves justice. I do not know. I have not heard that. And I would not recommend any of you to go file bar complaints against anyone. Bar complaints are usually filed by someone who has standing to do so. So the general public cannot go file a bar complaint against an attorney that they just don't like, who has not represented them or done something to them personally. So I would not recommend that in any way, shape, or form. Please do not do that. Yes, cross-pollinate. We do cross-pollinate. And that's why we usually check the schedule to make sure nobody else is doing something at the same time. You know what I'm saying? Do you know what I'm saying? Yeah, I know, Stacey. I was there. I was lurking in that chat because I'm trying to get John Ray to come on this show. He owes me a phone call. John Ray, if you're listening, we hung out in court one day during Jimmy Burke's arraignment. So when I say cross-pollinate, I mean we guest on each other's shows. So I have done, before I started my own channel, I started on Police Off the Cuff, guesting there and doing a lot of legal analysis on that channel and also on Duty Ron to this day. And I still do. So that is that. Fallstar, rank the following legal research: Reddit, ChatGPT, Subset. I'm not touching that one with a 10-foot pole, but people do it all the time. So, I don't know. Yeah, there may be a little projection going on here, Shuri, but I don't know. Let's get back to the papers, shall we? Having now reminded defendant of the outrageous conduct it refuses to address, none of which was compelled by DCF, plaintiff will respond directly to defendant's motion. To make this response more manageable, plaintiff will follow the format and organization used in defendant's motions. Plaintiff does not, of course, agree there were errors, etc., as alleged in the defense headings. But to respond initially to some themes in those motions, plaintiff offers the following. Oh, plaintiffs, I say this every time I read one of your motions or responses, and I just beg of you, could you please number your paragraphs? Just number your paragraphs. I don't know why. Is it a thing in Florida? I always number my paragraphs. You have to number your paragraphs. It just makes it easier to refer back to things. And nothing's ever numbered. At least the pages are numbered. As defendant acknowledged during the trial, this case is unlike any other. Thus, comparisons to other torts and verdicts in other cases, such as where a plaintiff died after a lifetime choosing to smoke, are of very limited value. And we went over that at length as well. I was very confused as to why they were using the verdicts in the tobacco cases to say that Maya's verdicts were too high, because some of the tobacco cases had lower verdicts, and we discussed that smoking is a choice and Maya had no choice. So I don't see the comparison there, and I'm glad that plaintiffs adopted that argument as well. Contrary to defendant Sky's falling claim that if this verdict Contrary to defendant Sky is falling claim that if this verdict stands, no facilities will agree to shelter children, the result here will mean that no facilities will treat a child and her family as defendants treated the Kowalskis. Bam. That's it. I don't even need to read it anymore. There's like 83 more pages, but I think that's the end of the argument right there. Defendants said in their papers, Your Honor, if you allow this verdict to stand, no hospital will ever, ever, ever want to shelter a child again. And plaintiffs turned that argument around right on them and said, no, that's not true, Your Honor. What will happen is that no facilities will treat a child and her family as the defendant treated the Kowalskis. So there. Mic drop. Mic drop. Sit down, boo. Welcome, new member, Miss Scarlett. Miss Scarlett became a new member? Yay. I don't ever beg for money on here. I don't put a ticker up in the corner asking anyone for money. I don't expect anybody to ever give money, ever. This channel is free. If you would like to contribute, it is very appreciated. If you would like to become a member, it is very appreciated, but I do not expect that of anyone. So please do not feel any obligation. That is another Reddit thread I found about myself. And it was actually very positive. It was like, she has integrity. She's not begging for money. She doesn't put up a ticker asking people to contribute. Lizika, there was a person I read it today trying to say the police covered up that Beyonce did a bag of K before killing herself. I think it got shut down pretty quick. Most people, oh my goodness, really? Are they moderated at all, this Reddit stuff? I don't do Reddit, so I don't really know. Does anybody moderate that stuff, or is it just like a wild free-for-all? I don't know. The Florida Supreme Court long ago rejected the logic adopted by the defendant here that JHACH should be given blanket protection by Chapter 39's immunity provision, even though JHACH violated and abandoned its duty of care to Maya. More than 30 years ago, the Florida Supreme Court addressed this inverted logic. In this case, that says, in a variation of the duty argument above, HRS also argues that even if it violated its duty of care, Section 827.077 statutorily immunizes it from liability. We do not agree. To so read, Section 827.077 would turn Chapter 827 on its head by protecting the legal protector, HRS, from the protected class. Section 827.07 protects against liability for carrying out the protective measures of Chapter 827 on behalf of the protected class. It does not protect against failing to carry out the protective measures. So this is when DCF used to be called HRS and Chapter 39 used to be called 827.07. And I just saw something really, really nice come up in the chat, and thank you so much for that. Christina Ward, for your very, very, very generous super sticker. I appreciate you so much. And that is on the heels of me saying I do not expect anybody to ever contribute anything, but I thank you. I thank you so much. That is very, very kind of you. Unchoosy heretics. I was reading your comments last night on the last live stream that I did, and you had some words in your comments I have to even look up. Like, your vocabulary is absolutely amazing. And Miss Scarlett, thank you again, Miss Scarlett. So what the court is saying here is that the immunity does not always apply according to this logic. So they are saying here, whether DCF, a sheltering institution, or a foster family, those who find themselves entrusted with the care of children via an intervention by DCF have a duty of care. A person taken into custody is owed a common law duty of care. To find that a custodian breached the duty of reasonable care, a plaintiff must show the injury to have been a reasonably foreseeable consequence of the custodian's negligence. JHACH is no different. Having been entrusted with Maya's care during her sheltering, the hospital owed her reasonable care. Defendant abjectly failed to care for Maya, instead placing her in harm's way of its agent, Dr. Sally Smith, to prove the, quote, charade, end quote, and Beatty to carry out her perverted motives. I love that. I like that they're keeping it classy here. You see on the one hand, some of the stuff that the defense has said in support of their motions, and the choice of words is just so important. I mean, there is a way to keep it classy, and I think I have to give plaintiff the classy points on this, because we've seen a lot of unclassy things. Yeah, the perverted motives. Plaintiff repeatedly put defendant on notice of the harm being visited on them, as demonstrated by the risk management records and a letter addressed to Dr. Jennifer Katzenstein complaining of Beatty's inappropriate conduct. Yet, despite the actual knowledge and foreseeability of this harm to plaintiff's family, defendant took no action. No child had ever been sheltered in defendant's hospital for as long as Maya, over 3 months. Because Maya's situation was unprecedented, defendant's dire prediction of the negative impact this verdict will have on other sheltering facilities is unwarranted. Upholding the jury's verdict, however, confirms that the sacred duty to care for children also extends to sheltering institutions, including children's hospitals. I would extend that argument to say that because no child had ever been sheltered in JHACH for over 3 months, that this was unprecedented, that it is absolutely egregious that the Risk Management Committee did not know that this was happening. When Dr. Napolitano testified at his deposition, and his video deposition was played for the jury, he said he did not learn about Maya Kowalski or her case until he read about it in USA Today in April or May of 2023. Explain that. Explain that. Then they went to Chapter 39 immunity, and they say that the court carefully carved out all of the Chapter 39 immunity issues before the trial, and that it wanted the jury. Defendant successfully opposed that motion because it wanted the jury to know about Chapter 39 immunity. Defendant now regrets its strategic decision, claiming the Chapter 39 immunity was used as a sword and not a shield. Aside from being wrong, defendant got what it wanted and cannot now blame anyone but itself. Defendant should be glad the jury did not hear the full extent of its and its counsel's active role in prosecuting the DCF proceeding and urging the dependency court to implement the constraints and restrictions on the family's visitation rights that defendant attempted to hide behind during trial. We have also discussed this at length, and the fact that Howard Hunter was involved in real time, and that he was in court during the dependency hearing after Beata took her own life, arguing for Maya to be transferred to an out-of-state facility as an inpatient psychiatric patient, and or to be placed in an out-of-state medical foster care home and receive psychiatric outpatient treatment after Beata took her life, after Beata was no longer a, quote, threat to Maya in their eyes. And Howard Hunter was arguing all of this in the dependency court as a non-party to that action. That should scare you. That should scare the bejesus out of you. The hospital was not a party to that action. They were a shelter for Maya. And the jury didn't hear anything about that. Regardless, they came to the verdict that they came to. Georgina doesn't even want to ever visit Florida. Yeah, this is scary. This is scary, Skoda. We really need checks and balances against DCF. I know. Pinellas County is one of 6 counties in Florida that has a privatized system. It's part of the false start. Taking Maya out of state, it really feels close to trafficking. It's just like, what's your argument? Your argument is that Beata is a threat to Maya. Beata is committing medical child abuse, and therefore we have to shelter this girl in our hospital and keep her away from her mother because her mother is the one who's making her sick. And yet, when her mother's gone, they're still arguing to keep her away from her family. It doesn't make any sense. It flies in the face of reason. Kim says, my husband and I did foster care for 10 years, and I could tell you there's a lot of abuse going on in institutions, including hospitals. JHACH, sad truth and heartbreaking. That is heartbreaking. And what a nice thing for you to do, to open your family to foster children. You're an amazing person. You and your husband. 10 years, that's amazing. I think the system needs more people like you guys. Right, LB, and they weren't worried about Kyle. Susan, you guys, this is happening in more states than just Florida. What can we do? I don't know. Well, let's think about it. But I agree with you. Keelan, I love the Melanie says Howard Hunt's name. I know it's such a New York thing. It's Howard Hunter. Howard Hunter and Ethan Shapiro. I don't know. They're probably watching. I'm just, it's a Saturday Night Live skit, people, but it's Monday. We'll call it Monday Night Live. Susan's seriously thinking of fostering because of this. That's amazing. That's really amazing. Colleen, foster parents are angels. The good ones are so self-sacrificing. Okay, let's do this, guys. Here's another thing that we're bringing attention to tonight and throughout the course of covering this trial, not just CRPS and the people who have it and chronic pain disorders and how patients who have them are often medically gaslit and told it's all in their head and nobody believes them. We're also bringing attention to the privatized DCF system and how your parental rights can be stripped within a couple of days if you take your child into the hospital and they falsely accuse you of something. But also the importance of foster care and loving foster homes. And I love that you guys brought that up. And I love that, Kim, that you were a foster parent. And I love that some of you are thinking about it. And that is a change that we can make. Ms. Scarlett, there should be a law against privatization of DCF. Maybe that's something Dr. Joe's advocates can work toward. I don't know. I don't know his position on that. Cycle Mom times 4. Oh, I have 5. You win. You have 1 less than I do. The only way to change the system is to write your legislator to find your legislator. Get up here, legislators. Heine. Get up your legislators, Heine. Oh, Melanie Schuyler was also a foster parent about 10 years ago. That's amazing. Kim says, thank you, everyone. My daughter was in school because of her disability and they mistreated and suffered emotional. I'm so sorry, Kim. I'm sorry that happened to you. That's horrible. Okay, back to the papers. Then they're going to start their argument on negligent training. Defendant repeatedly asserts that the negligent training claim should have been directed out sooner and is another source of its problems. As discussed below, Florida law requires hospitals to have competent staff. Proper training and supervision is part of that mandate. As it notes, plaintiff offered to make that a part of the medical malpractice claim, but defendant refused. Without trying to assess blame, no agreement was reached. But all this is irrelevant because defendant ultimately acknowledged that negligent training was relevant to the punitive damage claim. See the November 6th transcript excerpt at page 7 to 13. Mr. Altenburn said, there may be some element of this negligent training that relates to punitive damages claim. All right, so that's how they're going to say that should come in. Specific intent. The question of whether defendant had the specific intent to harm Maya Kowalski for purposes of punitive damages claim or punitive damages limitation was properly on the verdict form for the second phase of the bifurcated proceeding per the standard jury instructions. Putting the specific intent question on the verdict form in the first phase would have introduced an issue as to the amount of punitive damages before a jury finding that punitive damages were recoverable. Defendant also has shown no harm from this because it is not argued, nor could it, that the amount of punitive damages awarded exceeded the maximum amount awardable. Then they're saying that defendant had the opportunity to present evidence on the specific intent issue in the second phase of the bifurcated proceeding, despite the court's repeated admonitions that the punitive damages phase would follow directly and immediately after the jury returned its verdict if it found in plaintiff's favor. Defendant apparently failed to prepare its evidence to rebut plaintiff's punitive damages evidence, and as a result, failed to present its evidence at that time. The delay beyond November 9th, defendant requested, was not reasonable and apparently was dictated by the vacation plans of one of the defense team members for the week beginning November 13th, as discussed next. And they're going to talk about time. Defendant's insinuation that it was harmed because the court did not give it adequate time to present its case was never raised during trial, nor did defendant use its allotted time or make a request for additional time that the court refused. The court did not make a definitive pronouncement that the trial could not continue into the week after November 9th. In fact, the court alerted the jury during jury selection that the trial may extend into the week following November 9th. Also, it was defense counsel who expressed reservations about extending the trial due to defense counsel's planned vacation for the week beginning November 13th. Ultimately, defendant rested its case in chief, having not exhausted its available time. This was the defendant's decision, and it's alone. I have to say that I agree with that argument as well. Thank you, everyone, for joining us tonight. Thank you, Patroness Glow, for thanking everyone for joining us tonight. Now they're going to talk about damages. The amount of compensatory damages awarded in this case were supported by the evidence. The jury is allowed wide latitude in setting non-economic damages. We talked about this at length as well. Pain and suffering damages are not tangible. You cannot really put a dollar amount on them. They're not things like medical bills that have been incurred or specific lost wages that can be calculated by an economist. Pain and suffering is an element of non-economic damages that are left squarely within the purview of the jury. And because the jury is the finder of fact in these cases, the jury's verdict is rarely overturned unless it is so egregious that there's no way that it can be upheld. So courts are very hesitant to overturn verdicts made by juries, but we will see what their argument is. Defendant offered no methodology or evidentiary basis of its own for the jury to use to calculate compensatory damages and told jurors to, quote, use your common sense, end quote. The jury was instructed, quote, although these claims are separate claims, it's possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damages awarded in the other claims. Defendant did not object to plaintiff's closing, suggesting the jury allocate the damages flowing from multiple acts by the same tortfeasor among the torts in the jury's discretion. Allocating among claims is consistent with the multiple events instruction where there are multiple tortfeasors. Plaintiff had proposed a much simpler verdict form that did not allocate damages among the different claims, which defendant rejected. So that's an important point. You can't complain about something after the fact when there was a much simpler way that the plaintiff suggested to do it and you objected to that. And now you're, crying that you didn't like the way it was done when you had every opportunity to. I can't decide which one I like the best. I don't know why this should overlap that, but it's not. But then you can't read it. Plaintiff presented a logical option for the jury to evaluate damages for Maya's physical and all family members' emotional pain. The jury heard testimony that Maya's CRPS is the most painful neurological condition from which a person can suffer. The few numbers defendant did suggest at trial, unsupported by any evidence, were numbers for damage as a whole, such as future medicals, not apportioned by the claim. So it's too late for defendants now to argue for limits on specific items when it did not share those numbers with the jury. Contrary to defendant's conclusory statement, as discussed below, the punitive damages bore a, quote, reasonable relation, end quote, to the amount of compensatory damages, and none of the punitive damage awards exceeded the statutory cap set forth in section 768.731A. Defendant forgets one purpose of punitive damages is deterrence, and does not argue the amount was unreasonable in light of the large amount of its assets. The jury paid rapt attention to both sides, was respectful to counsel, took copious notes, and asked thoughtful and penetrating questions of both sides. The court religiously reminded the jurors of their duties, and they consistently reaffirmed they were following them. This court observed that this jury did its job. You guys doing okay in there? All right. Thank you, Betty. The jury did a very good job, in my opinion. Galen says, can I say that it's so nice to have a classy chat. Thank you, mods. Thank you, mods. Thank you. Oh, thanks, Night Owl, for liking my hair. Thank you. It's kind of a rush job, so I appreciate that. Oh, I'm sorry, Dog Defender. Oh, you just lost your dog of 10 years. I'm so sorry. Oh, I'm sorry. We're praying for you. That's really sad. Kim, you're in Massachusetts? Okay, let's talk about the Karen Reed case later. I want to know how you feel about it. Okay, we'll come back to that. Juror number one, they're just going to address this briefly, which is interesting. A key theme of the motion is that the jury was under the leadership of juror number one, and the verdict, therefore, was tainted. This is pure conjecture, as discussed in plaintiff's response to defendant's motion for a new trial based on the purported conduct of juror number one. Defendant has offered no facts whatsoever in its motion that showed any juror acted under the leadership of other jurors. Moreover, a verdict is not subject to a JHACH based on matters that inhere in the verdict, i.e. those that arise during the deliberation process. Whether the other jurors viewed juror number one as a leader would be just such a matter. Under Florida Standard Jury Instruction 700, the jury is directed to accept a, quote, leader in the form of a foreperson as its first act during deliberations. Then they're going to talk about the jurors' ability to understand the case, because that was a big part of the defendant's motion, that this case was way too complex, and there's no way that these bus stop people could have understood the issues in the case. Right, guys? Still got to get that bus stop picture taken. Finally, another key theme of defendant's motion is that this case was just too complicated for the jury to understand, and its verdict shows it was confused. The medical and scientific evidence was complex, end quote. Quote, a difficult intentional tort for a jury to understand. This high-profile case presented to a national audience would be nearly impossible for most juries, even with a different foreperson. Defendant goes so far as to say the case is, quote, easily 9 times more complex than the normal case, end quote. Respectfully, that is nonsense. Simply because defendant was unable to persuade the jury it did nothing wrong does not mean the case was too complex to be understandable or that the jury was confused. Rather, the evidence and the verdict reasonably show the jury astutely saw through the defense. Perhaps the result would have been different had defendant shown even a modicum of contrition or acknowledged it could have handled the situation better. Juries routinely handle complex issues, including lengthy and complicated intellectual property, antitrust, conspiracy, and medical malpractice cases. The jurors' thoughtful questions throughout the trial in this case showed they closely followed and understood the evidence as it came in. And we are just at the table of contents. But we did say that. We did say that perhaps in their closing, they could have said something like, we're really, really sorry about what happened to Maya, and we wish, maybe we should have handled things differently. There's a lot of ways that they could have shown just a little modicum of remorse, regret, sympathy. But instead, they sort of said, don't award a lot of money because if you do, you're going to be taking away money from children with cancer. And don't punish us because of Kathy Beatty, because Kathy Beatty doesn't work for us anymore. They could have a lot of different arguments, theories, just shown a little bit of compassion, just a little bit. And if somebody can point to me where they did show some compassion for someone other than themselves in either of their closing statements after the case in chief or the punitive damages phase, I would love to hear it. Hi, Callie girl. Yeah, that's my ASMR voice. Some people say they like to listen to me read at night because it puts them to sleep. It's very soothing. So, I'm here for it. Whatever you guys want. Yes. Yes, Miss Scarlett, even if they just had a little class. It's like the narcissist's apology. I didn't do it. You imagined it. But if I did it, it really wasn't that bad. And if I did do it, well, you absolutely deserved it. And even if I did do it, you're totally overreacting. Wasn't that bad. Julia Cochran, the lawyers can't talk about taking money away from kids with cancer. What would their fees be? Paul Star Wright, quote, things could have happened differently. Mistakes were made. We're all human. We're trying to do better. Yes. We've made changes. We've put safeguards in place to make sure this doesn't happen again. We've learned anything would have been better, in my opinion. Yes. Yes, I'm trying to highlight this. Night Owl, they're like, yeah, I'm sorry you feel that way. Not, I'm sorry I made you feel that way. It's, I'm sorry you feel that way. It's not what I meant. It wasn't intentional. I didn't mean it. I didn't do it on purpose. I didn't intend for you to overreact like that. Yep, Georgina, the narcissist apology. Absolutely right. Hi, Ray. Skoda, why even choose to work at a children's hospital or to defend a children's hospital if you're like that? I just don't get it. They just don't get it. Kim, this is gaslighting on steroids for sure. Susan, that's totally it. Narc apology. Yes. Yes, yes, Night Owl. They're like, look what you made us do. It's like a Taylor Swift song. Look what you made me do. Look what you made me do. Okay, yes, Tiff, they're really going to learn now. They are really going to learn now. Night Owl, Mishapir's Major Cast later. Thank you, Robbie. Just remind everyone, please hit the like button. It does help the channel, the algorithm, something like that as such. Pure hates, I'm sorry that you feel that way. I agree with you on that. The table of contents is quite lengthy, so I've highlighted some pertinent portions for us to go over because I don't know about you. If you want me to read to you all 89 pages, you can chime in here because I know there are other people that are doing this tonight. You can go back and watch the entire thing. Or in fact, you can actually get this yourself from the Sarasota website and read the whole entire 89 pages and the several hundred page supplement with all of the exhibits in it. I do have an email address. Who asked that? Somebody asked that. It is fanbase@mlittlelaw.com, and you are free to email me. I always read the emails. I do not always get a chance to respond to them. So yes, beautiful messy ball. fanbase@mlittlelaw.com. It's better than trying to message me on any social media because if you try and message me on Instagram or something, it kind of goes into like this black hole and I never find it until a long time later. And same thing with like Facebook Messenger, like it just doesn't really work. Plus I don't really use Facebook at all, ever. I just find it to be incredibly harmful to everyone who uses it. Really, guys, it's just a way for them to grab your data. It's not really about making friends, Facebook. It's not. They just want your data. And so many people are giving it to them. Listen, I have news for you. National Daughters Day is not a real holiday. It's not. It's a way for this algorithm to know who your children are. So when you post pictures of your daughters on National Daughters Day, now the algorithm and the software knows exactly who your children are and who's related to who. It's a big database, and that's what it's for. So don't post pictures of your daughters. There is no National Daughters Day. It's not a thing. It's just not a thing. Please, beg of you, please. Yes, National Sunday. They want your DNA too. They do. They want it. 23andMe. Everybody wants it. National Sunday. Yes, National Sunday is not a thing. It's just not a thing. And moms, please stop posting pictures of your teenage daughters in bikinis. Please. Thank you. It's getting to the wrong audience. It's getting to the wrong audience. It just is. Just don't do it. It's not classy. Please stop. Speaking of all this weirdness, I just watched a movie on Netflix last night. I'm going to recommend. It's with Julia Roberts. And hang on, I got to find the name of it. Did anybody watch it yet? It's the new Julia Roberts movie, Leave the World Behind, it's called. It's on Netflix. Very interesting. Like the world's gone crazy kind of movie with Ethan Hawke, Julia Roberts, and Kevin Bacon in there for good measure too. Mahershala Ali. It was very good. Yeah, it was a weird ending, right? It was a weird ending, says Julia. Yeah, a little bit weird. I know. They're telling you that the fourth Sunday in September is National Daughters Day because they're in cahoots. Kaiser Suits is that? I can't remind. They made it up. It's not a thing. It's not really a thing. My credulity is strained. It's not a thing. Don't fall for it because Skoda, same thing. I remember my kids once gave me a 23andMe DNA test for Christmas years ago. I still have it. I haven't used it. Oh my God, they're not getting my DNA. It's a database. They said they sell your data or use it in ways you didn't intend, but you worked in data. Yeah, you know. Faceplant. I call it fake book. Faceplant is a time sucker. It was interesting, Tiff. The movie was interesting. I would say I'm glad I didn't go to the theater to watch it. It was like an interesting way to spend 2 hours in an afternoon. So it was Kevin Bacon is always a good measure. Yeah. Thank you. Thank you, Liska. All right. Tell me where you want to go with this, you guys. Do you have like specific things in here that you want to cover? Do you have specific questions? Kim, there's a t-shirt or a mug. Don't hurt my credulity. Yeah, or it strains my credulity is strained. I think that's what I landed on. My credulity is strained. Oh, I got to watch it twice, Lita? The movie? Okay, some things come together the second time. Also, yes, Melanie, we are all related to Kevin Bacon. 6 degrees of separation from Kevin Bacon, all of us. Hi, Jules. I'm glad you came. OB, you're cracking me up. OB. All right. Now to the argument on directed verdict. Let's see. I don't know which one we like. I can't. Not working for me. Okay. They talk about the standard for a directed verdict. A directed verdict cannot stand if the evidence is conflicting or different conclusions or inferences can be drawn from it. The court may not pass on witness credibility or weigh the evidence. So basically what they're saying is it's the jury's job to decide the facts of the case. And if there's different conclusions that can be drawn, the court cannot overturn it. If there's different explanations, it's the jury's job to do that. And so you can't just direct the verdict in their favor. And they have a lot of good case law here. A directed verdict is appropriate only when there is no evidence upon which the jury could rely in finding for the non-moving party. We saw lots of evidence. I think we can possibly agree that the jury was able to come to their conclusion based on the evidence and the facts as they interpreted them to be. As for the new trial, a trial court may order a new trial when the jury's verdict is against the manifest weight of the evidence. So again, it is directed to the sound, broad discretion of the trial judge, who, because of his contact with the trial and his observation of the behavior of those whose testimony the finding of fact must be based, is better positioned than any other one person to fully comprehend the process by which the ultimate decision of the triers of fact, the jurors, is reached. However, a trial judge is not free to behave as a super juror by disregarding a jury's verdict simply because the judge would have rendered a different one had it been the judge's choice to make. The only credibility question defendant raises is Maya's recollection of the photography session at motion 66-67. But there is no question clothing was removed and pictures taken while defendant's staff held Maya down. Defendant does not contend this issue. The credibility of witnesses is a key to the court's evaluation of its new trial motion. Therefore, oh, Jules, did you get your shirt? Oh, good. Yes. Take a selfie in your new Team Maya shirt. I'm glad it came. Sometimes the shipping can take a long time, so I'm glad you got it. Hi, Sandy. Thank you for the question so that we don't have to read this. If you want, I find it kind of boring if I just read to you. I feel like we need to talk about it because I feel like a lot of you already know what these issues are and pretty much know exactly what the plaintiff is going to say. What are the chances of a new trial? What are the chances of lower damages awarded? Well, I don't think they're going to get a new trial. I don't think this judge is going to reverse himself. I don't think he's going to find any misconduct on the part of juror number 1. And I think he's probably going to laugh this motion out of court on Friday. It's on Friday, right? The 15th? For many, many reasons that we've discussed at length. There may be a chance that some of these damage amounts may be lowered. There may be a settlement, and that would be amazing. I wish that the case would settle. I wish that they would agree on something and just get rid of it. But for example, we can fast forward to a page a little further down where the plaintiff is saying, okay, listen, here's something that you absolutely should reduce, and we're going to agree to that. So if they consent to reduce some awards, and we had talked about this, or I had talked about this, or I brought this up about the past medical expenses, the plaintiff in these motion papers says, okay, we agree, just reduce that. We agree with that. So here is the standard. Let's talk about the standard for remittitur, which is the lowering of the amounts that the jury awarded. The Florida applicable statute states that after a jury awards damages, it shall be the responsibility of the court, upon proper motion, to review the amount of such award to determine if such amount is excessive or inadequate in light of the facts and circumstances which were presented to the trier of fact. The trier of fact in this case is the jury. The purpose of remittitur or additor would be increasing the amount of the verdict, is reflected in section 768.743, that it is the intention of the legislature that awards of damages be subject to close scrutiny by the courts and that all such awards be adequate and not excessive. In assessing, quote, whether an award is excessive or inadequate, end quote, the court, quote, shall consider the following criteria. A, whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact. Whether it appears that the trier of fact ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damages recoverable. Whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation and conjecture. Whether the amount awarded bears a reasonable relation to the amount of damages proved and the injury suffered, and whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. So that's the criteria that the court shall consider in determining whether or not the award is excessive in this case, which is what the defense is asking the court to do, reduce the amount of the verdicts. They say the court must also review a punitive damage award to ensure that the manifest weight of the evidence does not render the amount of punitive damages assessed out of all reasonable proportion to the malice, outrage, or wantonness of the tortious conduct, that the award bears some relationship to the defendant's ability to pay, does not result in economic castigation or bankruptcy to the defendant, and a reasonable relationship exists between the compensatory and punitive amounts awarded. A punitive damage award must further satisfy the federal constitutional requirement of due process by the court's measure of the award according to 1, the degree of reprehensibility of the defendant's misconduct, and 2, the disparity between the actual or potential harm suffered by the plaintiff and the punitive damages award, and 3, the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. Then they go on to talk about the similar cases and how the tobacco cases should not even apply here, because comparisons with other cases are sometimes fraught with danger because, of course, each case is different and must of necessity be measured in the light of the circumstances peculiar to it. To characterize this as a unicorn case understates the horrific acts defendant committed in combination to inflict damage on the Kowalski family. Until defendant can bring forward a case where the jury found the defendant liable for battery, false imprisonment, medical malpractice, and intentional infliction of emotional distress, a comparison of verdicts in other cases is of limited value. Defendant has not produced even a single case where 3 out of the 5 torts committed here were committed simultaneously by one defendant. Defendant suggests that this case should be compared to smoking cases because of the size of the punitive damage award. But those cases where adult smokers voluntarily engaged in conduct once the dangers were well known are not remotely like what defendant did intentionally, as the jury found, to this young girl and her family. Saying that the cases that they cited really have nothing to do with this, and therefore the court should disregard those questions, those cases. Defendant never gets around to demonstrating to the court what reasonable range the jury could have properly operated within, and cannot make such a showing from the record since the defendant failed to put on any evidence suggesting an appropriate measure or range of damages. Likewise, the defendant cites no false imprisonment, battery, medical malpractice, or intentional infliction of emotional distress cases to demonstrate a reasonable range. Apples and oranges, they are saying apples and oranges. You can't compare this case with adults who chose to smoke, even though the tobacco companies may have lied or misstated that cigarettes were addictive, and didn't have proper warnings on their labeling. One of the main cases that defendant cites, they failed to mention that in this particular case, there is an element of speculation in most personal injury verdicts, but this is a matter for jury discretion. The court may review their discretion, but not the amount awarded unless shown to be clearly arbitrary. The determination of the amount of such damages is peculiar. All right. Well, you know what it says. I'm not even going to spell it. Peculiarly within the providence of the jury. In fact, defendant's arguments throughout the remainder of its motion demonstrate that the jury's verdict was consistent with the per diem calculations plaintiff suggested, and though defendant complains of the methodology, only an award in line with defendant's closing argument would have been arbitrary. Defendant's suggestion in closing were drawn from its hip pocket rather than being based on record evidence. They have a point. If you didn't agree with the numbers, you should have put on some evidence as to what you thought the numbers should be. And they didn't do that. And they didn't call an expert to say what the damages should be. And therefore, the only expert from which the jury could draw its numbers was the economist, Christy Carlson, right? Is that her name, Christy Carlson? It is a tongue twister, right? Peculiarly. 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 Peculiarly? Peculiarly. No, everyone's hungry. That's hilarious. That's going to keep me awake tonight. I'm going to be trying to figure out the pronunciation of that word. Not a word that you use very often either, is it? Oh, that's funny. Tina, he couldn't say that word either. Peculiar. Peculiarly. I don't think it's a word. I'm going to say I don't think it's a word. We shouldn't even have to say it. All right. Jules, I want to sue JHACH's law firm, but I can't. Did you talk to a lawyer about that? I don't know if absolute litigation privilege applies to this case. But I also, in all fairness, and thank goodness, I don't think that they've really disparaged you as horribly as they have juror number 1, which is really no consolation to you. But you didn't do anything wrong, Jules. You didn't do anything wrong. And whether absolute litigation privilege would apply to them in your particular case, you're not a party to the action. I don't know. Yeah, they have legal litigation immunity, but it's not so broad that it applies to every single case. They're trying to say that in the Petito civil case as well. Bertolino, the lawyer in that case, is trying to say that there's litigation privilege, absolute litigation privilege immunity. And so anything he said was in support of representing his clients, and he can't be sued for it. So I don't know. Yeah, juror number 1 was decimated. I mean, Jules, you're tough. They tried. They can't touch you. Everyone knows you did nothing wrong. It's probably worse what he said to you in person. I mean, that was just ridiculous. Ridiculous. Kim Watts got it correct. Now we're gonna have to go back and look. I'm not recommending. I'm not going to recommend that anybody file any bar complaints against anybody, because that's what they want to do against me on Reddit, because I gave out Hunta's PO box instead of anybody wants to write him a letter. Oh, thanks, Robbie, again for your super chat. Guys, I have to run. If I don't see you, have a great Christmas. Love from Australia. Bye. Bye, Robbie. Merry Christmas. Oh, it's peculiarly. Oh, I said it. Peculiarly. Like Worcestershire sauce. We know what it is, but you can't say it. It's Worcestershire sauce. Worcestershire. I know I got that right. Did I? Did I get it right? Worcestershire? Any of my British friends in the chat? All right, I have to say I agree with that argument. They didn't give the jury any other way to calculate damages, so complain now. Deference to juries continues under the statute. Come back, pleading, come back. Statutory review of jury awards by the court is not intended to replace the discretionary authority historically given to juries, and the legislature recognizes that the reasonable actions of a jury are a fundamental precept of American jurisprudence, and that such actions should not be disturbed or modified with caution and discretion. Because of the inherent difficulty in measuring these kinds of non-economic damages, this court has determined that the jury, guided by its judgment and everyday life experiences, is in the best position to make a fair assessment of these damages. There is no exact standard for fixing the compensation. This deference to the judgment of juries has been recognized specifically regarding damage awards and wrongful death actions, because who can place a dollar value on a human life measured by the loss and grief of a loved one? That difficult decision is generally one for the jury or fact finder, not the appellate court. We discussed that at length during the trial. How do you put a price on that? Can't. It's up to the jury to decide. Likewise, the wide latitude accorded juries has been especially true of punitive damages awards, which are, they're going to say it again, peculiarly left to the discretion of the jury, as the degree of punishment to be inflicted must always be dependent on the circumstances of each case, as well as upon the demonstrated degree of malice, wantonness, oppression, or outrage found by the jury from the evidence. Well, the jury was outraged. Their credulity was strained over and over and over. The trial court itself also has a limited discretion to interfere with a jury verdict and must give due deference to the jury's broad discretion to fix compensatory and punitive damages. Here's what the Second District said about reducing jury damage awards in tort actions. Where recovery is sought for a personal tort or where punitive damages are allowed, we cannot apply fixed rules to a given set of facts and say that a verdict is for more than would be allowable under a correct computation. In tort cases, damages are to be measured by the jury's discretion. The court should never declare a verdict excessive merely because it's above the amount which the court itself considers the jury should have allowed. The verdict should not be disturbed unless it is so inordinately large as obviously to exceed the maximum limit of a reasonable range within which the jury may properly operate. Limited authority is therefore accorded to the trial court to check the occasional haywire or runaway jury verdict without in turn giving the trial court a blank check to do so. And then the next argument, a determination of an excessive award must be based on specific facts showing impropriety. Although the defendant has asked throughout the motion for a remittitur of the various awards, it also posits that remittitur is not possible in this case because the awards are so arbitrary that they cannot even be used as a reliable measure for remittitur. Based on that concession and the absence of any evidence or understandable methodology presented by defendant as to what it contends the verdict amounts should have been, the court should decline any remittitur. It's another good argument. Talk about some pleading, talk about some Chapter 39. Defendant concedes there are limitations on the type of conduct that will obtain immunity under Chapter 39. Defendant just disagrees with where the court drew the line. The court crafted a thoughtful omnibus order concerning Chapter 39 immunity relatively early in the case. The court applied these standards set out in Urquhart, requiring only that the defendant have a reasonable suspicion before reporting child abuse. The court's omnibus order noted that the Urquhart and Ross decisions appeared not to have not considered the separate and coexistent good faith requirements set out in Chapter 39. Nonetheless, the court applied the law as it exists and entered summary judgment on many of plaintiffs' claims as a result. The causes of action that survived beyond the court's application of Chapter 39 immunity were those that could not be considered to have been authorized or required by Chapter 39. Those included false imprisonment, battery, medical malpractice, negligent training, fraud, and intentional infliction of emotional distress. For each of these claims, defendant cannot and has never been able to point to anything in Chapter 39, the dependency court's orders, or DCF directives to authorize or require its actions. To take a couple of examples. 1. At no time did DCF or the dependency court authorize Maya's false imprisonment between October 7th and 13th, and neither could defendant justify its conduct through Chapter 39, which expressly prohibits a hospital from detaining a child beyond 24 hours absent a court order, which it did not have. Similarly, a hospital or any sheltering institution cannot batter a child, and it is absurd to suggest that the battery of a child is or was authorized by the Florida legislature or the dependency court, and the sheltering hospital is not free to commit medical malpractice on a child simply because it has been entrusted with the child's care and custody by the dependency court. Yes, I have to agree with somebody in the chat here who says, don't give them the satisfaction of getting to you, Jules. Oh, don't. Rise above. Lauren says, I can't spell this morning. Melanie said Worcestershire correctly. That is a county in UK. The sauce is without the shire at the end. Kim says, yes, Jules, stand in your truth and power, girl. You got this. You got this. Kirsten, thank you. Hit the like button. Hit the like button. Lisa, I watched a training Sally Smith gave around my time in the hospital to say it was so cringeworthy, but exactly what I expected. Oh, I think I watched that a long time ago, too. I think I did. OB, Jules, you should sue them for straining your credulity. Scotta's cackling right now. In a chat, pronunciation. And we're focusing more on pronunciation today because I think all of you already read this motion. So let me ask you if you have any specific questions about it that I can explain to you. Worcestershire. Yeah, Worcestershire. That's what I say. That's the way I was raised to say it. My father put it on everything. It was the base for his salad dressing. Worcestershire. Lee and Perrins, too. You can't have any other kind of Worcestershire except for Lee and Perrins. That's the one. It's the only one. It's the only one that matters. Kirsten, everyone's drinking in the chat, huh? What do I think will be the outcome here? Well, let's see. I think that we should all just relax as we look to, we'll fast forward a little bit. Let's see what the plaintiff already agreed to. I think perhaps some of the numbers on the medical bills will be reduced and or agreed to. But I do not think that any of the dollar verdicts for the pain and suffering awards will be reduced. I don't think they really shock the conscience. And I also think that the punitive damages award, really, when you think about it, 50 million, when the compensatory damages were 211 million, are kind of low. So I think you better want what you wish for, kind of, right? So let's see what we have in the papers that I highlighted. Because like I said, this was a lot of work to do today. And I think if some of you are coming over from the other channel, you've already read the whole entire thing or had it read to you. So let's look at the portions that I highlighted for emphasis and what we think is important over here. Okay. As far as battery goes, defendant's argument that the batteries did not involve striking with a fist or a weapon, again, shows defendant still does not get it. Under defendant's position, a sexual battery would not justify a large compensatory award. That's right, you guys, we talked about this too. Remember, people said, oh, so if you're, SA'd or R'd and it only lasts for 10 minutes, that shouldn't be worth a lot of money because it was quick. That it can't cause post-traumatic stress disorder for the rest of your life. Defendant ignores that the harm here was not simply the unwanted contacts, but that Maya had to endure them from a woman she found intolerable, who at the same time was telling Maya things like she would be her mother now and that Beata was in a mental institution. The harm was exacerbated when Maya was deprived of her mother's touch forever. It also ignores Maya's testimony on how painful her CRPS made those touches by a staff trying to show she did not have CRPS. And yet, they billed over $500,000 for CRPS treatment. Plaintiff adopts the responses above on compensatory damages, including defendant's failure to suggest a meaningful alternative, etc. Defendant asks, where is the clear and convincing evidence of actual knowledge of wrongfulness and high probability that injury or damage would result, and that defendant intentionally pursued the course of conduct? The jury was entitled to conclude the acts they heard about at trial, some are recited above and include battery, false imprisonment, and the myriad hateful things defendant's staff did to a 10-year-old girl, were done with knowledge they were wrong and at defendant's direction. Remarkably, in this case, the jury observed one of those rare, a few good men moments when the tortfeasor confesses on the stand. Beatty admitted that she took photos over Maya's objections and tears, and that despite the 10-year-old child's efforts to resist, unfortunately, we did take the photographs at the direction of risk management. They cite Beatty's deposition where she said that. Unfortunately, we did take those photos. Beatty exhibited an appalling conscious disregard for Maya's rights. The jury was entitled to draw the inference from defendant's relentless actions. Speaking of, A Few Good Men is really one of my favorite movies. I think that's one of the movies that made me want to become a lawyer. That was an amazing movie. When Tom Cruise was young, Demi Moore was in that movie, Jack Nicholson, one of the greatest legal movies of all time, in my humble opinion. You can't handle the truth. You can't handle the truth. Good night, Colleen in Nashville. Good night. Yes, Jules, I say you should consult with an attorney to see if it's covered by litigation privilege. It may not be. There may be exceptions to that rule. It's not just a blanket thing. You can't just do whatever the hell you want just because something is in litigation and expect that there's never going to ever be any repercussions, in my opinion. I don't practice in Florida. I practice in New York. But there needs to be some sort of parameters there. It's not a free-for-all, in my opinion. Scott Miller, wait, if risk management directed them to take the pictures, how did they now know about it till earlier this year? She says, Kathy Beatty says risk management told her to take the pictures. Risk management really didn't know much of anything. According to Dr. Napolitano, he read USA Today. That's how he found out about Maya Kowalski. OB, please, everyone, don't go to Florida. Everyone's telling Jules to check it out. Check it out. Hi, Scott. Good night. Who's leaving? Kel's leaving or Scott's leaving? Susan Cornwall, the motions filed by the defense seem to be nonsensical and desperate, while plaintiffs' responses are based in fact and law. Yeah, and they're not full of hyperbole, right? They're not, it's not full of hyperbole. There's a lot of reasoned arguments in here. I want to get to the part that I told you about where they're agreeing to reduce the damages. But let's take a look here. All right, so here's the billing fraud issue that I brought up in the original motion of the defense. And I said, this is one area where I may agree with the defense that they may get this part of their motion granted. So here's plaintiff's response to that. Defendant's insistence that no paper bill was introduced is both factually incorrect and ignores Jack Kowalski's testimony that he paid toward the outstanding balance and paid increasing premiums following Maya's discharge. Plaintiff understood that defendant had agreed that evidence on medical liens would be introduced after the verdict and consequently suggested the jury award nominal damages. While the amount by which the liens may exceed the non-CRPS charges because of defendant's fraudulent billing may be substantial by comparison to the liens, plaintiff does not want to incur delay litigating that issue. Consequently, plaintiff reiterates his willingness to reduce this award to a nominal amount. There are statements in the defense argument plaintiff could challenge, but will not take the court's time to do so. They go on to say why defendant is wrong and ranting. But again, while plaintiff expects a hearing on the liens would establish a damage figure in excess of $1, plaintiff does not want a further delay in the entry of the final judgment. So the plaintiff is agreeing to reduce that award to $1. I can't remember off the top of my head, but I think it was $500,000 that they awarded for billing fraud. It doesn't say. What does it not say here? They go on and on to say that all of these numbers that defendant wants to reduce, they're not saying they're just pulling numbers out of their hat. So therefore, the numbers that the jury awarded should stand. I agree with them. Okay. Here they talk about the issues affecting the claims presented by the estate of Beata Kowalski. Intentional infliction of emotional distress, seeking survival damages, renewed directed verdict motion, and new trial motion. Plaintiff will elect the wrongful death claim, but responds to defendant's legal arguments, which it adopts for the wrongful death claim. Defendant's factual spin ignores the concerted action harming Beata, immediate retaliation against Beata for challenging defendant's doctors and urging them to discharge her daughter, refusal of the family's request for discharge and false imprisonment of her daughter for having challenged defendant's doctors, another woman, defendant's social worker, kissing and touching her daughter while telling Maya she would be her mother, and that Beata was mentally ill and had been placed in a mental institution. The same social worker suggesting divorce to Beata's husband, interrupting phone calls between mother and daughter, and isolating Maya, denying her cards and gifts from her mother, etc. Defendant then poses another rhetorical question, quote, "What evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of human decency, atrocious conduct utterly intolerable in a civilized community, and did so with intent to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing that stress?" The answer is easy. Defendant's doctors exchanged text messages in which they predicted Beata's suicide, having had another mother do the same thing. We discussed this at length as well. Dr. Laura Vose, who testified by deposition at trial and bizarrely served on JHACH's ethics committee in 2016 and as co-chair on JHACH's ethics committee in 2017, texted Dr. Tepa Sanchez shortly after Beata's suicide to relate that in the lead up to Beata's ultimate demise, she had predicted Beata would take that final step. Whether this evidences intent to cause Beata severe emotional distress or reckless disregard of the high probability of causing Beata's suicide is a question the jury did not have to answer. Either way, defendant's ethics committee had actual knowledge of Beata's severe emotional distress and failed to intervene. Defendant lashes out at plaintiff for having resorted to a great conspiracy theory and a plan akin to a Mission Impossible episode. Defendant then weaves a theory that plaintiff did not argue and ignores that the court granted defendant's motion for summary judgment on plaintiff's count for civil conspiracy relatively early in the case. As explained above, the court ruled in defendant's favor when it renewed its objection to Dr. Neuberger's mention of a conspiracy and excised that testimony. Defendant waived any other argument that this lone utterance of the word, quote, conspirator elsewhere in Dr. Neuberger's testimony justifies a new trial, since defendant did not renew its objection to that word or testimony and did not ask for a curative instruction after Dr. Neuberger's testimony was read. Further, one utterance of the word conspirator in the context of a 9-week trial is harmless error, if error at all. Plaintiff argued before trial that Beatty was the hospital's hitman, but that term and other similar terms were excluded when the court granted defendant's motion in limine. In short, defendant's elaborate, quote, doctor's revenge novella is not a rehashing of evidence presented to the jury, but rather defendant's attempt to paint the jurors as conspiracy theorists. Although there was evidence from which one could infer that a doctor's revenge conspiracy existed, plaintiff did not argue that theory. Rather, plaintiff focused the jury on multiple, atrocious, intolerable, extreme, outrageous acts. The actors included Ms. Beatty, Dr. Vose, Dr. Sally Smith, Dr. Dees, Dr. Tepa Sanchez, Dr. Dolan, and last but not least, JHACH's Risk Management Department and its senior counsel, Jackie Crane. There were likely others involved, although the notable absence of any testimony from a risk manager or Ms. Crane leads to the natural question. If defendant's straw man doctor's revenge conspiracy theory orchestrated by risk management was so easily disproven, why did defendant not call anyone from the risk management department to testify, especially considering the prominence of the damning risk management notes throughout the trial? The standard instructions given by the court do not require that Beata heard or witnessed the cruelty in person, and the court has rejected adding that gloss to the law. Defendant's actors had to expect Beata would hear their taunts of Beata losing her child, her husband, and her freedom being committed, and the harms they inflicted on her 10-year-old daughter. Defendant not only attacks plaintiff for a conspiracy theory defendant alone has articulated, defendant then attacks this court, as it did in open court, for not performing its gatekeeping function. They do blame the court for a lot, don't they? For defendant's desired list of actions, it need only look at the highlights of its actions above: the 8th amended complaint, the order granting leave to assert punitive damages, and the response to defendant's motion for summary judgment. A simple list, however, does not capture the relentless frequency of this conduct, the death by 1,000 cuts. The jury was entitled to infer defendant orchestrated the conduct, perhaps to deal with a mother who offended or challenged the wrong people, those being unqualified doctors wearing JHACH lab coats. The court exercised its gatekeeping function throughout the trial by excluding Beatty's correspondence documenting that she and the hospital were pushing for further restrictions on Beata's visitation rights without justification. Beatty's arrest record for physical violence on a child similar to Maya's age, and excluding the presence of that arrest record in Beatty's personnel record, reflecting and proving without a question that defendant knew of Beatty's violent history. Defense counsel's cease and desist letter to Mark Zimmerman to avoid the jury learning that the defendant drove the dependency proceedings, and the sexual assault of Maya documented in defendant's medical records, and the failure to report that sexual assault to the Florida Abuse Hotline, which was other outrageous conduct the jury could have considered. So these are all the things that the court did not allow into evidence. So despite the fact that defense is now claiming that the court did not act as a gatekeeper, plaintiff is now pointing out how, in fact, the court did act as gatekeeper in not allowing any of this very damning evidence, in my opinion, in. The jury was instructed on substantial cause, and defendant's unsupported statement that the jurors could not sort out the causes is just that, unsupported. Defendant's professed inability to see the disdain and hatred the, quote, ketamine girl text evinces reaffirms that defendant just does not get it. Plaintiff will indeed elect the wrongful death claim over the survivor claim, so nothing more needs to be said about survivor damages. So that indicates to me that they are going to waive the survivor damages because it seems like they needed to elect one over the other, and they are choosing to elect the wrongful death claim. So they are conceding some things here, giving the court an out, as it were. I'm going to come to the chat now, see if you guys have any questions on the stuff that we are going over so rapid fire. Sandy, this case was so egregious, any jury would have awarded the same or more. I agree with you. I'm going to unplug this thing because I don't need it because I don't have anything playing in it. So let me know if this affects my sound to you. Shouldn't. Hey, Night Owl. I loved when people grift. You said grift. I think you meant gift memberships. It's a great way to support the channel and help it grow. Thank you. Yes. If people gift memberships, you need to just opt in, and somehow it randomly awards them to people in the chat that are participating. So thank you, whoever gifted those memberships. I really appreciate it. Galen. Oh, Galen, you're such a grifter. I mean, gifter. It is late. It is late. Plaintiff should not have given an inch, Georgina. Look, Georgina, sometimes that's how the best settlements are made, by negotiating. And hopefully this case will settle and can settle, and it would be great if it did, and this didn't have to drag on for years and years and years. Hi, Scott Millard. Can you please explain the difference between punitive and compensatory damages? I don't quite understand. Compensatory damages are things that you prove during the course of a trial. So compensatory damages are things like pain and suffering, lost wages, past medical expenses, future medical expenses, loss of parental care and guidance in the case of a wrongful death, for the survivors, loss of consortium, which is sort of like losing the companionship of your spouse. And punitive damages are meant to punish the defendant. If the conduct by the defendant is completely egregious, with total wanton disregard for the plaintiffs, they are allowed to, in some cases, very limited cases, in fact, award punitive damages as a deterrent, as a way to punish the defendant, if that makes sense. I hope that answers your question. Could you explain how plaintiffs are conceding on Beata's death? Let's go back to the papers. Let me see if I can answer that after we get through the rest of these papers. Hang on. And we may need to go back to the defense motion to see what their argument was. Let's continue here. Intentional infliction of emotional distress causing death by suicide. Plaintiff adopts the responses above. Defendant continues to recast the facts in a matter the jury loudly rejected. Leading up to Beata's suicide, defendant continued to inflict psychological and emotional blows on Beata. In the 30 days leading to Beata's suicide, the time frame defendant focuses on, defendant 1, ignored Beata's request to have Beatty removed from Maya's care. 2, then allowed Beatty to molest Maya in the chapel. 3, refused to allow court-ordered visitations by phone and FaceTime, isolating not just Maya, but inflicting further severe emotional distress on Beata. 4, refused to facilitate family therapy sessions ordered by the dependency court. 5, ignored Beata's medical decision-making rights that had been preserved for the dependency court and tormented Beata by further threatening to remove Maya's port. 6, did not allow even a single FaceTime call between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls at both 11 a.m. and 5 p.m. each day. And 7, and then directed Beatty to threaten Maya that she would not be allowed to attend court and see her mother if she did not submit to stripping for Beatty and subjecting herself to semi-nude photographs. Beata was the target, and she knew it. Then they go through some of Jack's testimony, where he said that Beata was becoming more desperate and that he was reporting back to Beata about what was going on, that Maya wrote him a note, and that's how he knew about these things. When she couldn't get the dress that Beata had picked out for Maya, Beata was crushed. And he said that you could just see that Beata, it was just eating at her. She lost a lot of weight during this time. Beata learned much of this directly, even when her visitations were routinely shut down by Beatty. Instead of focusing on these horrific facts, defendant plays the same game it did at trial, hiding its head in the sand. Rather than attempt to explain how it was that Maya did not have any FaceTime calls with her mom in those last 10 days, despite the dependency court's December 27th order expressly requiring those calls, defendant instead focuses on a couple photographs taken on or just before Christmas with Maya smiling and holding a present. The same approach failed at trial when defendant opted to ignore Beatty's horrific actions and instead played a video of Maya playing piano in the hospital lobby with an unidentified physician and exclaiming, "This is Johns Hopkins." The jury rightly rejected defendant's saccharine version of events when plaintiff displayed defendant's horrific, outrageous acts with the correct motto, "This is the real Johns Hopkins." Defendant's public policy threat to this court is preposterous. If the court does not grant relief on this claim, no rational hospital administrator will be willing to keep a child in DCF custody for any period beyond the point where the child is eligible for medical foster care. Rather, Florida's public policy will be served by reinforcing with rational hospital administrators that hospitals cannot falsely imprison children without legal authority, should not covertly videotape children, should not entrust sheltered children to the care of violent social workers with criminal histories, should not direct the battery of children in their care, and if the administrators are aware that their actions are driving a mother towards suicide, they should address the hospital's failings, not hide them. Skipping to a motion for a new trial based on errors related to the testimony of Dr. Richards, plaintiff says, defendant failed to call a psychiatrist to explain what led in defendant's collective mind to Beata's suicide. So defendant resorts to an attack on Dr. Scott Richards, whose expertise and opinions have been known to defendant since the Chapter 766 pre-suit process began. As defendant points out, Dr. Richards never met Beata due to her tragic suicide. On this point, Dr. Richards is no different than all defendant's experts who testified at trial. Dr. Elliot Crane, Dr. Randall Alexander, Dr. Sharon Levy, and Mark Anderson, none of whom had ever met Maya, Kyle, Beata, or Jack, but each was more than willing to opine on the family's behavior and Maya's condition. Unlike Dr. Levy, Dr. Richards reviewed the entirety of defendant's medical records and thousands of pages informing his forensic opinions. Contrary to defendant's unsubstantiated charges against him, he assumed nothing. Motion for new trial on excessive compensatory damages, Remittitur. Plaintiff adopts the prior responses on allocating damages among the claims, the jury's discretion in setting damages, etc. Conclusion. Defendant re-argues the same positions the jury rejected, continuing to deny the horrific nature of its actions. Plaintiff Jack Kowalski individually and on behalf of MK, a minor, and as personal representative of the estate of Beata Kowalski, deceased, respectfully requests this court deny defendant Johns Hopkins All Children's Hospital's motion, dated today, December 11th, 2023, and served electronically on the defendant at the same time. This was filed today, right before 4 p.m. And that, my friends, is what I consider to be a very classy response to this motion by the plaintiffs. Kim says, nice reply, Attorney Andrews. I'm with you there. What say you, my friends? What say you? Good night. Good night, Princess Mish. I don't know about that. LB, I truly believe if the jury had have awarded less in the actual medical costs, they would have awarded more in the punitive phase. That may be. What year did she pass? The beginning of 2017, January of 2017. Kaylin, how do these people get away with this crap? That's a great question. That is a great question that I cannot answer. Chapter 39 immunity provides immunity for anybody who reports child abuse or things that happen in these dependency court proceedings in Florida. I do not think the same immunity is awarded here in New York, because I do know that there is a federal lawsuit pending on behalf of the estate of Tommy Valva by his biological mom against the Suffolk County Department of Social Services, or CPS, and all of the individual social workers who may or may not have failed in protecting Tommy Valva, a 10-year-old boy who froze to death in his father's garage due to abuse, for which he is now sitting in prison along with his monsterly fiance. But the biological mom of Tommy Valva tried to get CPS to pay attention for years, and no one did. And look what happened. And she is now suing them in federal court, all individually. And as a group, no real changes have been made in Suffolk County. So Chapter 39 in Florida does not seem to have a sister statute here in New York. Yeah, Skoda, that's a bad case. Right, I don't think so. I think everything is state by state. You know, Florida seems to have a lot of I don't know, generous laws. Florida seems to be a very generous place for plaintiffs. Some of the counties are known to give away really, really big verdicts, kind of like the Bronx here in New York. They say if you have an injury case here, you want to be in the Bronx because the juries are very generous. Yeah, Georgina, me too. That does break my heart so much. And Justina, who's the mom in that case, the Valva case, the plaintiff, her attorneys have just withdrawn as counsel because she didn't want to accept $3 million as a settlement in that case, which I think is a ridiculously low amount. So I'm not really sure what's going on there, but I have that complaint and I have all the motion papers and I want to get into that at some point. But this breaking news keeps breaking. So we have to take a look also at that Valva case. If you're interested in that, let me know. I'd like to cover that. Nope, right? Not enough money in the world. There is not. No, Sandy, that poor mother is right. Yeah, she's also from Poland. She's also Polish. You are right, Patroness Glow. Yes. Adam Montgomery. Yeah. Anybody know the date on that? I definitely want to cover that 100%. I don't know if it's going to be, I think it's going to be televised. If anybody doesn't know about this Adam Montgomery case in New Hampshire, it is horrific. He was given custody of his daughter, Harmony. He was a longtime felon, admitted drug abuser, drug addict. He was given custody by a Massachusetts judge, took his daughter to New Hampshire, and she wound up in pieces in a suitcase. It is a horrifying case of Harmony Montgomery. I have the date for that trial in my calendar. I just can't remember off the top of my head what the date is on that Montgomery case. Charles, we need to pay attention to all the copycat cases spinning out of this one if we don't want bad laws made to fix this. Agreed. Yes, she's Polish, right, Justina? I agree. I believe she is. Yes, do that Valva case. Boy, and there's transcripts from some of those proceedings where that judge would not listen to a thing that she had to say. She had evidence that these boys were being abused. Two of her sons were in the custody of this guy who was NYPD and his fiance monster. And they were both, I believe they were both autistic. And he died in that freezing cold garage. It was a very tragic case for us here on Long Island. Yeah, Tiff, that does hurt my heart too. Right, false star. The current structure is creating some pretty perverse incentives that do the opposite of what is intended here. This says Straws. Yep. False star says 3 million for those circumstances. Minimum 50 million, preferably 250 million. 3 million is insulting. Yeah, and I'm surprised. I don't know why the attorneys withdrew. Did they want her to accept the settlement and she didn't want to? I don't know if she's found another lawyer, but maybe Greg Anderson would take her case. I know that the court did give her more time to find a substitute attorney. So hopefully somebody will step in and take that case and she will see some justice for Tommy Valva. It's heartbreaking. It's heartbreaking and it's happening every single day. Thank you, Kim Watts. February 6, 2024 is the Adam Montgomery case, same day as your husband's. Oh, happy birthday to him. You're going to be watching the trial all day. You'll have to just go out for dinner after it's over. Ray sounds like she's an absolute bulldog. Yeah, we have a couple of those out here on Long Island. No, Betty, they were not forced to withdraw. They actually made an application to withdraw. I saw the papers. They asked, unlike the Delphi case where they were forced off the case. That is crazy too. So yeah, right, Rachel, that Harmony case is awful. It's awful. Yeah, I don't know about the Hernandez case. I can't comment on it. I don't know anything about it. I will look into it though. Speak life. Always coming in with the comments. Dear Reddit, look, if you or your family was abused or treated like crap by a medical providers and I was aware, I'd stand for you as well. It's vital we send a clear message. We don't accept this as most people can't fight. Thank you. Thank you very much. This puts a financial burden on the parents to now go hire an attorney or sell their vacation home to now represent themselves in a dependency court proceeding that may have zero to little basis in good faith. And if you watched Sally Smith's proffer during the trial that the jury did not see, she was very adamant and very militant that she did not think that it was her job to submit the medical records about Maya that would confirm that she had CRPS. That wasn't my job. That's their attorney's job. Because now the financial burden was on the Kowalskis to hire an attorney to represent them in that proceeding. See how that works? See how unfair that system is? Very unfair. Lorraine's advice, Ray, first thing, get a lawyer and say nothing. I agree. K-Pick or the attorney selling their vacation home like Anderson and his wife did. They sold their personal property and moved because of this case. Wow. Wow. That's dedication, huh? Wow. I was interested to find out that Anderson's firm does mostly defense work. So as much as these Redditors are bashing Greg Anderson's firm, the majority of his practice is defense work. So, you know, it's about the cause, I guess, in this case, not the attorneys. Shannon Baird, listening to them talk in court was like watching paint dry, but this response is awesome. One step beyond you. I see Sally Smith is in a gatekeeper role. The only problem is the gate says, I'm not even trying to pronounce that one. Yeah, them bringing out that whole Nazi thing is just beyond. I mean, they pulled it straight off of Reddit. I went through it the other night. I was pretty mad on that. I was on fire. I was like, smoke was coming out of my ears. I had to calm down before I was late because I had to calm down because I was so angry. I was so angry about it. And I had all kinds of graphics about how maybe he's a Kiss fan. Maybe he's an AC/DC fan. Maybe he's a Tampa Bay Lightning fan. Maybe that's where the lightning bolts came from. And it was just so out of control. So out of control that they would bring that up. I've never seen anything like that before. But the more that I do this, the less I'm surprised, I guess. Georgina, you like that? Work sets you free, one step beyond you. It was on the gate of Auschwitz. Oh my. Let's go to. Never seen a pediatrician that is a permanent frown or scowl before. Yeah, that's what they call RBF. If anybody knows what that stands for, don't spell it out in the chat, but they call it RBF. Oh my goodness. Oh my goodness, Miku. Miku, you got to see the Supreme Court of Indiana released their Delphi. Okay, maybe there's a show idea for tomorrow. Is that the Supreme Court of Indiana? All right. Okay, I'm going to get to that. Don't anybody go watch that yet. Don't anybody go watch that. So the rulings came out today, Miku, huh? All right, I'm going to have to get on that right now. Right now. All right. And if there are any other further pressing questions, I think that we can wrap for tonight. Thank you to my amazing moderators who keep the chat classy all the time. You guys are the best. I love you. Couldn't not do this without you. To all my channel members, my little cupcakes, I love you guys too. In case you are new here, that's my logo. I am not a cupcake, because that pink sign is my daily reminder. You cannot make everyone happy. You are not a cupcake. This is not a neutral channel. I have opinions. I do share them. They do change with every case, depending on the facts of the case, the rules of law, the Constitution, and the procedure. So if you want to watch, you're going to get my opinions. And although I may not make everyone happy, my cupcakes and make me happy, and I make them happy, and that's why we are cupcakes. I know it's kind of confusing, but whatever. I thought it was cute. Melanie's Little Cupcakes, that's the name of the membership. And so thank you also to the viewers, the replay viewers, everyone who supports me with your super chats and your super nice emails and your support in every way and gifting memberships. And here's Dave the Pious just joining. Thank you, Dave. I don't know when you put that in there because these don't timestamp, but thank you for your super chat. And for everyone, please, if you wouldn't mind just hitting the like button, it helps the algorithm. I don't know, if I knew the YouTube rules, maybe I could get, I don't know, more views on this stuff. So I know you guys like it, so I'm just going to keep doing it just for you. Thank you again. Remember, be cool, be kind, be classy. It's not hard. And I will see you guys really soon, maybe tomorrow, who knows, but hit the bell so that you'll get all notifications and you'll know when I go live. Because sometimes I just do it 2 hours in advance. I don't really schedule things so far in advance. All right, you guys, I'll see you soon. Peace out.